Good morning, everybody. It is 9:03 on June 9th, and this is a regularly scheduled meeting of the Oil Conservation Commission. I'm Adrienne Sandoval, Chair of the Oil Conservation Commission and Director of the Oil Conservation Division. Would the other commissioners please introduce themselves for the record?
Yes, Madam Chair. My name is Greg Bloom. I'm the designee of the Commissioner of Public Lands. Thank you.
I'm Dr. William Ampuma. I am a professor at New Mexico Tech and also a designee of the Energy Secretary. Thank you.
Also with us is Florine Davidson, Clerk to the Commission, and Chris Moander, Counsel to the Commission. All right. Is there a motion for approval and adoption of the agenda?
Madam Chair, I so move.
Actually, I'm sorry. Hold on a second. I'm sorry. Never mind. I was looking at the wrong agenda, an older version. So go ahead.
Okay. Madam Chair, I move to approve the agenda for today's meeting.
Thank you.
Madam Chair, I do second.
Mr. Moander, would you please do a roll call vote?
Happily, Madam Chair. Dr. Ampoma.
Approved.
Commissioner Bloom.
Approve.
Madam Chair.
Approved.
The motion carries.
Thank you. Is there a motion to approve the June 3rd meeting minutes?
Madam Chair, I so move.
Madam Chair, I second.
Would you please do a roll call vote, Mr. Moander?
Yes, Madam Chair. Dr. Ampoma.
Approved.
Commissioner Bloom.
Approve.
Madam Chair.
Approved.
The motion carries.
All right. Next item on the agenda is review and voting on order in case for de novo case number 22474, OCD case number 22294, application of COG operating for compulsory pooling. Commissioners, have you reviewed the order, and is there a motion to adopt the order in this case?
Madam Chair, I have reviewed the order and I move to adopt the order in this case.
Madam Chair, I've also reviewed the order and I do second the motion.
Mr. Moander, would you please do a roll call vote?
Happily, Madam Chair. Dr. Ampoma.
Approved.
Commissioner Bloom.
Approve.
Madam Chair.
Approved.
The motion carries.
All right, agenda item number.
Madam Chair, and I apologize for interrupting. Since I think that there's a copy circulated to all the commissioners, the sooner we can have that signed, the better, so we can circulate that to the parties.
Ms. Davidson, did you circulate a PDF version of that with an order number?
Yes, I'll do that.
Okay, thank you. All right, great. Now moving on to agenda item number 5. Motion hearing and status conference for de novo case number 21744, which was application of Cimarex for de novo hearing. Mr. Padilla and Mr. Savage, can we hear you?
Ernest Padilla for Colgate Operating LLC.
Good morning, Madam Chair, Commissioners, and Council. Darren Savage with Abbey and Schill, here today on behalf of Cimarex Energy Company.
Okay. I think we have a handful of things we need to address today. I believe, and Mr. Moander, correct me if I'm wrong, but we've got 2 existing motions that we need to address and rule on today, as well as getting an update from the parties and status.
So, Madam Chair, and this is a little bit convoluted today, as is the nature, it seems, of this case. So there is currently an outstanding motion filed by Mr. Padilla. Behind that motion was a motion filed by Mr. Savage that the commission didn't take action on. And then behind that, there's the still outstanding motion to dismiss applications by Mr. Padilla, and then the motion to invalidate the division order by Mr. Savage. Those were held in abeyance some time ago and brought back to the commission's attention through Mr. Padilla's motion. And then I think the other issue then will be discussing the order that was adopted last month by the commission and addressing one of the issue in there about the de novo hearing. But I think that's the chronology here in order to best deal with things in a fairly coherent method.
Okay. Sorry, it cut out a little bit for me, I think, at the end. Can you just say that last bit one more time?
Yes, and then the final issue will be taking a look at the order the commission adopted at the last meeting. That'll be the last item, I think, to be addressed.
So motions and then order.
Yes, I think that's correct.
Okay.
And Mr. Morander, I'm having a little bit of trouble with your sound when you lean back, when you sit back. It gets kind
You
of
know what?
an echo to it.
It's probably my office fan more than anything, so let me fix that. And that should help.
That does help. Thank you.
Okay. Mr. Moender, is there a preference on which motion to address first? There's the motion to invalidate and then there's the motion to dismiss.
I think the first motion that needs to be addressed is Mr. Padilla's motion to essentially have the commission readopt its order and have the parties argue that first. Because that's the most recent. Well, you know,
I think
honestly,
that was the motion to dismiss.
well, actually, so those are the two motions that were held in abeyance that the commission has yet to rule on. So I think you could start with that as well. Actually, I don't know that it really matters so long as I think the last thing we do is address the order in and of itself.
Okay. All right, well, let's start then. Actually, let's start with the motion to invalidate. I think that maybe makes the most sense. They were both filed around the same time. Mr. Savage, you submitted that one. Can you please make some, and I believe you submitted, Mr. Padilla made a reply and then you made another response. So could you please briefly make a statement on that motion?
So as I remember this particular motion, the motion was to invalidate was raised, submitted to consider the question of whether or not the de novo hearing granted because Cimarex is a party of record, was deemed a party of record, whether it should go back to the OCD for review if it turned out that the application was not pursued in good faith under the statutes and the rules, or if it was determined that, then the forum would be for the de novo hearing would be at the commission level. It looks to me like the motion has been decided based on the evidentiary hearing that the motion, the arguments in the motion were reviewed during the evidentiary hearing, and the question of good faith in terms of the interaction between Cimarex and Colgate was addressed. So I think the motion has been addressed.
Mr. Padilla?
Well, it's rare for me to agree with Mr. Savage's rendition of the arguments, but I agree with him. I think the commission effectively ruled that that motion was denied by by the commission's determination that there was good faith on the part of Colgate. So I agree.
Anything additional, Mr. Savage?
Not on this particular issue. Thank you.
And Madam Chair, I'm going to suggest we do all the voting here at the end. I'm collecting the information and I can assist with that. Because I do think some of there will be additional discussion today that I think will have an impact on the vote and consideration of this motion.
Commissioners, do you have any questions about this motion?
Madam Chair, not at this time.
Madam Chair, no.
Okay. All right, then let's move on to the motion to dismiss that was filed by Mr. Padilla. Mr. Padilla, would you like to make some statements on that?
Sure. My when we wrote that that motion, we were Cimerex had filed applications for as part of its de novo hearing. We filed a motion to deny those motion that motion or those applications simply because Cimerex had not done anything necessary to perfect its application in terms of the rules of the commission and the rules of the Bureau of Land Management with respect to the potash area. There's a complicated procedure for making applications for compulsory pooling in terms of drilling wells within the potash area. But that said, it seems to me that the commission's order, the latest order, Order C, already took care of that just by implication. The commission denied the de novo applications, which I think when you look at the whole picture, it validated those applications. The Cimerex application calls for a 3-mile lateral that it just baffles me in terms of how that was drawn up in order to essentially mess up the Colgate applications that had been in place and which have been approved by the commission. So I don't see, here we have a chicken and the egg, which is first the chicken or the egg kind of thing in terms of Cimerex applications. Those are only a reaction to the issues raised in this hearings and an attempt to make an argument that its applications should be considered on a de novo hearing. But once the commission denied the applications, then I think it erased everything in the process. All of the applications, and so effectively the commission denied those or granted Colgate's motion to dismiss the applications. The rehearing motion, I think, addresses perfection of an appeal by Cimerex in the district court. So I think the commission has already effectively granted those that motion to dismiss by its order, latest order, and I think it's already been heard.
Mr. Savage.
Yes, thank you, Madam Chair. As I understand on this particular motion, is this the original motion to dismiss? Because it was my understanding that the original motion there was an original motion to dismiss filed by Colgate, and that was denied by order R21679, and based on that, the commission stated it was granting a de novo hearing, and therefore granted the stay of the underlying pooling order. That's how I'm understanding this, but I'm not. If there was there a subsequent motion to dismiss, Mr. Melander?
Mr. Savage, that's correct. There were two filed. There was an
Okay.
original motion to dismiss. This was the motion. This was filed immediately after you filed your competing applications.
So
this
okay, it was the motion to dismiss the competing applications.
Yes. Yes.
Okay,
just
not
so-
the application for de novo hearing. Not the.
Correct.
Okay.
Yes.
Okay.
That's
Okay, thank you, Mr. Melander. That's an important distinction. Madam Chair, I'm not sure how much more Cimerex should present at this time in the proceedings. We believe that Cimerex has made its position and arguments clear in its application for a hearing of order R21679C, and in its response to Colgate's motion to affirm the order. As we stated in those pleadings, section 7213 of the Oil and Gas Act grants a de novo hearing to a party of record adversely affected by a decision of the division. Cimerex is a party of record adversely affected, and its application for de novo hearing was granted by order number R21679, and that occurred when that order confirmed that Cimerex was and is a party of record. The commission then agreed to bifurcate the case, and after the first part of the bifurcated case had been heard, the commission, it appears midstream in the proceedings, denied Cimerex's application for de novo hearing after it had been previously granted. We believe it was granted by operation of law based on the confirmation that Cimerex it became a party of record. And it looks like the most recent order thereby disallowed the hearing of the second part of the case as originally conceived and agreed upon. After the commission's initial grant of Cimerex's application for a de novo hearing, the commission, by subsequent order number R21679B, directed Cimerex to file competing applications and make them available for review. A directive that Cimerex fully complied with. So Madam Chair, it appears at this moment there are two competing development plans before the commission made available pursuant to the commission's directive and currently available for review. One from Colgate for its Meridian well, and one from Cimerex for its Crest wells. Now, one of the development plans submitted achieves optimal production better than the other one. One generates higher revenue for the state of New Mexico better than the other one. And one of them prevents waste and protects correlative rights better than the other development plans submitted, and therefore is in the best interest of the public. Now, whichever development plan is better based on these criteria and in these regards has yet to be determined. But the development plans are before the commission at this time. So Cimerex respectfully submits that if the opportunity exists before the commission as does now to prevent waste and protect relative rights by the review of competing applications made available to the commission by its own directive in order R 21679B, a directive that required Cimerex to file for review its competing applications by 5 p.m. on June 3rd, 2021. Then the commission, pursuant to the Oil and Gas Act and case law, should have an obligation to review the competing applications in order to prevent waste and protect relative rights and protect the interest of the public. And therefore, we believe that the Colgate's motion to dismiss the competing applications should be denied. Thank you.
Any follow-up, Mr. Padilla?
Well, we can always make arguments on waste and correlative rights. And I think we argued that waste and correlative rights are the paramount objectives or duties of the Oil Conservation Commission and of the division. But Cimerex hasn't put anything forward that would help the commission in terms of right now demonstrating that the commission did not take those issues into consideration. 2-mile laterals, for one thing, are the standard in the industry these days. To say that in argument that one 3-mile lateral is going to be better than a 2-mile lateral is an issue of fact. But this case has always been dealing with procedural issues. Cimerex, despite the commission's ruling that allowed de novo hearing, simply has failed to do anything correctly in this case. As demonstrated by the commission's ruling on good faith. We argued that it dropped the ball, and it continuously dropped the ball throughout this process. Cimerex filed competing applications to begin with that had to be dismissed because they didn't provide notice to interest owners. And they're now in a second round of competing applications. And I think that the commission saw through that in its order, and its latest order, and effectively denied everything in terms of, and obviously Cimerex is entitled to appeal to the district court, and it's already on its way, technically subject to this hearings today. So I think they have the right to review, obviously, and so they can go to the district court. Thank you.
Okay, Mr. Moander, is it best to address these or address the order first?
There's still one more motion out there, and this is the one that is I'll call it purely outstanding, for lack of a better descriptor. And that is Mr. Padilla's motion, essentially for the commission to readopt the order below. I'm going to recommend we hear argument on that first, and then we're going to discuss the order. I think that's the best way to do it. So that way all the arguments are out. There's nothing left for the parties to argue, and then the commission can take up its discussion.
All right. I believe Mr. Padilla filed that one, correct?
That is correct, Madam Chair.
All right, you're up again, Mr. Padilla.
Well, I don't want to go beyond what we said in the motion to affirm, but it just makes sense that this case has to end somewhere. That this record is very complicated. Just simply filing that motion and doing the research on the motion to affirm, you almost have to look at the entire record, and it's heavy to see procedurally where we went, what was argued, and that sort of thing. The commission's order is very comprehensive. I'm astounded at the findings of the commission and the time that it took to come up with those findings and decide this case. So my feeling is that there's nothing more to argue. And if Cimarex feels that it needs to go on to the district court, then I think that's their prerogative. But to go back and say, well, we're going to retry this case, it doesn't make any sense. We spent nearly 2 days trying this case before the commission. And before that, a whole bunch of hearings on various issues of this case. So I just don't see how in the world the commission needs to go back and retry this case. It's got to end. And I think Cimarex has already viewed this case as being ripe for appeal to the district court. So I just don't, I think the commission ought to just readopt its order and simply take it the way it is, because it's done a lot of work to come up with this order, and there's got to be some finality to this argument. Thank you.
Mr. Savage.
Yes, thank you, Madam Chair. Cimarex believes that the general framework that was discussed to come up with a procedural posture for addressing basically which forum the competing applications would be heard in, that good faith, it was within that general framework of the procedural posture that good faith played a role. And the only role that good faith played was a consideration of whether or not the cases should go back to the OCD if there was not good faith on the part of Colgate, or to remain at the forum for consideration and review if it was determined that there was good faith. Basically, that general framework, and it was, and there was a lot of complicated discussions and variations of discussions in that. But I think everybody kind of agreed on the general framework because it was brought up during the April 4th, 2022, the April 4th status conference, when it appeared that the commission was wrestling with the discrepancy between denying the de novo application at this point in the proceeding and the prior adoption of the procedural framework that bifurcated the case and reserved the second part of the case for the second part of the proceedings. So that was the only place that good faith played a role. Now, in the de novo application, it doesn't matter whether or not an applicant at the OCD exercised good faith or not. The de novo hearing is a hearing granted as a right under the statute, and it's premised. It's predicated on the premise that the order was issued in good faith. So an applicant goes through the hearing process at the OCD level. They are presumed to have done everything in good faith. They get an order issued. A party of record has a right, if they're qualified as a party of record, and Cimarex was qualified as a party of record, has a right upon application within 30 days to have a de novo hearing. Whether or not the original applicant acted in good faith or not. In fact, we presume they did act in good faith. So because the commission recognized and confirmed that Cimerex was a party of record, the only consideration regarding good faith in the evidentiary hearing was the proper forum for the second part of the bifurcated case. And Madam Chair, we are only asking that Cimerex is only asking that it be given the same consideration for review of its competing applications submitted during the de novo process. That, for example, the parties in case numbers 21277 and 21278 and other precedential cases such as 22191 and 22192, in which it appears that the division and the commission acknowledge that they are moving in this direction where they, in order to prevent waste and protect relative rights, they believe it is important to hear these competing applications as a contested hearing. So that we request that the commission follow the precedent they have previously established and pursue this matter as a review of competing applications. Thank you.
So, Madam Chair, it looks like we're now going to discuss the order. Do you mind if I make a few comments here as we proceed into that?
Go ahead.
So I appreciate actually the recognition from both parties that this case has, to put it mildly, a complicated and lengthy history to it. So I will throw out a bit of a mea culpa here, and the commission's going to address this momentarily. I ended up confused about exactly where this case was in the course of drafting this order. I anticipate the commission will address that momentarily. I apologize to both the parties and the commission for the fact that my mind got completely twisted with going through everything. So I'm going to hand this back to Madam Chair, but I really do mean, or I'm glad to hear that I'm not the only attorney who looked at this case and had to actually go back and start from day one to begin to unwind things a bit more.
All right. Commissioners, before we go further, do you have any additional questions for Mr. Savage or Mr. Padilla on any of the pieces?
No, Madam Chair.
No, Madam Chair.
Okay. All right. So there are quite a few pieces to this. I believe that, sorry, that the order may need to, I mean, we need to discuss it, but I think it's created maybe a little confusion. So I believe just a really short history of all of this is the commission probably a year ago bifurcated, or I'm not sure if that's the right term, split sort of the two core issues of the application. First, there was the core issue of was good faith effort, was that met? And should the order from the division be invalidated? So that was one piece, which we spent, as Mr. Padilla said, 2 days listening to. There was another piece of the case. There was the de novo application for competing compulsory pooling. That piece has not been heard yet. I believe, okay, so in Mr. Savage's motion to invalidate, the request was essentially, invalidate the division's order or and or grant a motion or grant a competing compulsory pooling de novo hearing. The commission heard at length on the whole invalidation of the division order. And had earlier, I think, granted that de novo hearing, which was originally scheduled, I think, for today, but we switched it to a motion hearing. Okay, so that's one motion. Another motion was the motion to dismiss from Mr. Padilla. Saying that basically it was too early, things were too soon, BLM needed to go through their process. And that there should not be a de novo hearing at this point. And then there was the third one, which Mr. Padilla just mentioned, which was basically reaffirming the division's order. Okay, so then we have the order that we entered into last hearing, which says, I believe, the de novo application is denied. I believe that I think that has created potentially some confusion, because there are so many pieces to this case. I do not believe the intent of that was to deny the de novo application for competing compulsory pooling. That was intended to say that we are not rehearing this case again. It has been decided. It is not being remanded back to the division.
And Madam Chair, just to make sure your thoughts are clear on the record, I think what you mean is that the issue of the good faith notice, which was part one of the bifurcation, has now been decided. Is that correct?
Yes, that order was not intended to decide the de novo case for competing compulsory pooling applications. So that is, I think, sort of the short version of the very long history. Commissioner Bloom and Poma, do you have anything additional or thoughts?
No, Madam Chair, that's my view and recollection of where things are and how we got here. Thank you.
Yeah, Madam Chair, I don't have any further comment on that.
Okay. So, Mr. Moander, what is the best way to move forward? Should we vote on each motion?
I think to start off, Madam Chair, I think we need to address, basically amend the order is the way to go on this. Because there was an error. I copped to it. I made an error here, but there's an error in the order in and of itself from that order. I think the way to do that is that, or what would have been paragraphs 111 and 112 will be amended to reflect that to some extent, or the notice and good faith issue has been decided, that the matter will proceed to a hearing on the competing applications, and that you would remove that the division order stands because that has yet to be determined. And then we can proceed to the motions, because I think that, as Mr. Savage and Mr. Padilla noted, a lot of the decisions on those other on the pending motions or motions held in abeyance are impacted by the order, such that it'll make it a little easier to make motions on or make motions for the motions for a vote.
Okay, so first let's make a motion on the order then. Yeah. Okay. Do we have a motion to amend the previous order entered into by the commission?
Yes, Madam Chair, I so move.
Madam Chair, I second.
Is there discussion on how we should amend the order?
Madam Chair, I think Mr. Moander expressed how this can be amended so that it gets us where we need to go. That the de novo hearing mentioned in paragraph 111 is denied with respect to the OCD, but that at the OCC, we will still have a hearing on competing applications.
Okay. Mr. Moander, is that clear enough?
I think so. The only other point I would add for consideration is that that the division order be upheld, that order that just be stricken for further consideration after the applications are heard.
Okay. Will you do a roll call? Oh, I'm sorry. Go ahead.
Madam Chair, yes, and I would agree with that. Thank you.
And Commissioner Bloom, so just to be clear, is your motion now incorporating the changes as discussed, since that wasn't in your original motion? Was there a second to that by chance out there?
Yeah.
Thank you, Dr. Impone. And Madam Chair, would you like me to proceed the roll call?
Please.
Dr. Impoma,
Approved.
Commissioner Bloom,
Move.
Madam Chair,
Approved.
motion carries.
So I guess, Mr. Moander, will you draft an updated order and do we vote on that at the next hearing?
Yes, Madam Chair. I think one thing I'd like to ask the parties before we secure that process is if the commission proceeds as just described by Madam Chair, would that in any way limit the parties from being prepared to present for the competing applications in July or maybe August? Aside from witness issues, of which I know I understand there may be some. Sounds like that'll work, Madam.
Yes. There's no objection on that. Thank you from Cimarex.
And Madam Chair, I will produce an amended order for the commission's consideration in accordance with the vote.
Okay. So then is it, I mean, this order seems to sort of wrap up the decisions of the prior motions. Is it cleaner to just vote
To
on
move on,
those?
At
or
some
move on?
point, Madam Chair, we're going to need to deal with any of the outstanding orders. Because I think the amended order that we're discussing, called the primary order here, I don't have the order number in front of me. I think the parties understand that impacts these motions. If you would like to table a vote on these motions, I don't think that's a problem either, because there may be some value in going back now and yet again taking another dive to make sure any motion properly disposes, or any motion by the commission properly disposes of those motions, because the parties are now on notice that this is proceeding to the competing application hearing.
Does that just kind of punt it?
That's exactly what it does, Madam Chair.
Do we, I mean, I'm kind of inclined to like clean things up, but
That is at the commission's discretion. I think that
go ahead.
I mean, I think just looking at this purely from the perspective of the amended order, that would probably mean that by operation, that would appear to deny Mr. Padilla's motion to reaffirm, deny the motion to invalidate the division order, limited to the extent that the matter will proceed to a de novo hearing for the competing applications, and it would result in the denial of the motion to dismiss the competing applications. I think that's how that would work.
I feel like I don't know if it's just me, but you're like fading out towards the end.
Oh, well, is this better? You
A
know,
little bit, actually.
I think my headset is probably dying. It's only been abused for 2.5 years, so
It's been loved.
it's had a good run. But yeah, I think that would be the sequence of things. On the other hand, you know, if the commission decided to table these to be determined, or for a final vote on all these motions at the close of the evidentiary hearing that'll be held, that also would be a good way to clean it up on the off chance something odd comes up during the course and scope of the hearing.
Okay. Do we need to make a motion to table the motions?
I would recommend it.
Is there a motion to table the 3 motions that we discussed today until the close of the evidentiary hearing for the de novo competing compulsory pooling?
Chair, I so move.
Madam Chair, I do second.
All right, would you do a roll call vote, please?
Yes, Madam Chair. Dr. Mpoma,
Approved.
Commissioner Bloom,
Approve.
Madam Chair.
Approved.
Motion carries, and the motion to dismiss application, motion to invalidate division order, and motion to reaffirm final order are tabled until the close of the evidentiary hearing to be held on competing applications.
Okay. At this point, that is not scheduled. Can we, I guess, sort of move to the status conference piece of this where we get an update from the parties?
Madam, I think that at this point, this is probably worth just getting to hearing at this stage, because the parties need to get this wrapped up. They fought valiantly on, the attorneys have on behalf of their clients. I think it's time to get this to what amounts to trial so the parties can get a final resolution.
Ms. Davidson, what do the next couple dockets look like? July, August, September. I don't know. Can you tell the commission what we've got on those dockets at this point?
Okay, for July, we just have the adoption of the final order and the rulemaking case that the commission heard. And I think the other case scheduled for today, the Spur Energy Partners, I think possibly that will be continued to July 14th. It's up to the commission. We have nothing else scheduled for the rest of the year.
All right. Thank you, Ms. Davidson. Mr. Savage and Mr. Padilla, is July too soon? Would August be better?
For me, August would be better. I'm going to be out, let's see, in July, from the 20th, 21st, and 22nd on another matter. And then I have a case in federal court that I have to really do some depositions. And so August would work better for me.
Mr. Savage? If you're saying something, you're muted.
I'm sorry. August would be fine with Cimarex. July or August is fine. Can I ask one point of clarification on this? So with tabling the motions, having the hearing of the competing applications first, does that mean there could be issues? Like, so for example, if the OCC made the decision on one development plan or the other, are there still outstanding issues that could affect that decision? Is that how that? Yeah, because your comments on your feeling that things should be cleaned up prior. I kind of feel that way as well. I'm just wondering if there's if the OCC made the decision to select one development plan, could there be outstanding issues based on those motions that could affect that decision? That's what a concern I would have.
Just to clarify, Mr. Savage, so like, for example, the motion to dismiss your client's competing application, is that the motion you're most concerned about? I'm guessing.
Yeah. I mean, that seems like it could be an issue. What is the other motion that's outstanding? That motion to invalidate?
Yes.
Okay, so that could potentially affect a decision in favor of Colgate. The other motion could potentially affect a decision in favor of. I mean, I think it'd be remote. It would be remote, but I think that it seems like it'd be a good idea to clean those up as opposed to having any ambiguous issues hanging over our heads. I mean, that's highly precautious. That would be my precaution.
Madam Chair, I think Mr. Savage probably does have a point here. I mean, I don't have strong feelings in any particular way because I have my own sense of where this is likely to go. But I can see the need to review the desire to have these decided before the hearing, because I think what Mr. Savage is voicing concern about is there's evidence that would come out that would somehow impact the status of those motions. I also think that the commission could make a decision that would inherently result in a denial. It would be an inherent or implicit denial or granting of a particular motion. And Mr. Savage, I'm assuming you would want rulings from the commission before the day of the hearing. Is that right?
That would be preferable, Mr. Melinda. I mean, the concern I would have is if one of the parties decides to appeal a final decision on the competing applications.
What constitutes the final decision?
How would the district review those outstanding decisions?
I think that that's a pretty valid point. Mr. Padilla, what's your commentary on this, if any?
I think an evidentiary hearing is going to decide Colgate's motion to dismiss the competing applications. And I think it would also invalidate or effectively rule on the motion to invalidate. In the commission's prior discussion on the motion to invalidate is that that motion could be decided on the merits of this case, and so would so tabling, as far as I'm concerned, would be appropriate because once you have an evidentiary hearing, the commission can decide both motions, especially our motion to dismiss. Our motion to dismiss is going to be based entirely on the merits hearing on the de novo. We don't agree with the de novo, but if we have to go to de novo, then that motion is going to be decided by whatever decision the commission makes. The only issue that I have with that is what is the scope of the de novo hearing? Is it just simply who can better develop the acreage at stake? Do we have to notice everybody? That has been one of my issues. Is that if we're going to start all over again, do we have to start from? I don't think we have to start all over again. It's just an issue between Cimarex and Colgate, and we don't have to go through all the notice requirements that are necessary with the division hearing, as you would in a division hearing.
So, Madam Chair, I think both sides have put out their arguments here. I think there's both sides have interesting and compelling arguments. I'll leave the decision, of course, to the commission. I'm happy to answer questions.
Mr. Miranda, could I respond just real quickly to
Oh,
that?
sure.
Okay, so that is a good
Well, Madam
question.
Chair, may he respond? I apologize for usurping authority
apologize.
Go
here.
ahead.
Madam
That's
Chair,
fine.
thank you. Um, so it is a good question that Mr. Padilla raises, the scope of this review. I'm assuming we refer to it as an evidentiary hearing, but I'm assuming that we're considering all the factors that the commission and division consider when selecting a development plan, and that this particular hearing will select a development plan to issue an order for operatorship. That's what I'm assuming. Is that correct, or is this falling short of that and addressing some of the motion hearings and whether or not one of the development plans is primed to go forward? I guess I'm a little bit uncertain about the final nature of the decision.
Mr. Moiner, it seems to me that we probably need to vote on some of these motions because I think the motions are gonna make clear what the case is that we're hearing.
I
The
think
competing
that's an
applications.
That's a reasonable interpretation, Madam Chair. Based on, I believe it was order R21679, the bifurcation was designed, I mean, there were two preliminary issues that have been argued and have now been decided by the commission. One of them was the party of record issue raised by Mr. Padilla very early on. So that was a preliminary gatekeeping matter on whether a hurdle that had to be overcome to get to a competing application hearing. Then Mr. Savage raised the issue, and we had a full evidentiary hearing on the issue of good faith notice, and now that's been resolved. So as far as I'm aware, having looked through the case, and I did go through the entire case recently, every single paper, that only leaves the competing application hearing. And that's essentially what I would call the merits hearing. So if you cleaned out all the motions today, that does not in any way mean that if there's evidence that comes up in the hearing, those motions can't be reviewed, or the commission may learn something that could change its position. The motions as they were drafted were obviously not with the benefit of the motion or the evidence, all the evidence in front of the parties. So cleaning them out, that still does not prohibit the parties from making their arguments about, for example, validity of the division order. And I think it might be somewhat semantic about whether or not dismissing an application is the same as finding an opposition to an application. It effectively dismisses it, but I don't know that I would say they're identical. So clearing them out now, I mean, it could be done here in a matter of a couple minutes, because I do think the commission is fully informed and has heard all the argument and seen all about all they need to see to rule on those insofar as the timing when they were filed.
Okay, commissioners, I know we voted a minute ago to wait until the close of the evidentiary hearing on the competing application, but at this point, I think I'm inclined to manage these.
Madam Chair, I think Mr. Savage raised good points there, and we can take these on now, perhaps with a motion to table, or I'm not quite sure what that would be. Or bring them back to the table.
I'm sorry, Mr. Bloom, I'm not hearing you.
Right. Yes, Madam Chair, I believe Mr. Savage made some good points there about resolving these before we go to the hearing about competing applications. And with that, I would be prepared to offer a motion to, I'm not quite sure what that motion would be, Mr. Miranda, to untable or bring back to the table. Reconsider the three motions in front of the OCC. I would perhaps see if Dr. Ampoma has feelings on this, or perhaps would proffer a second to my motion.
Yeah, Commissioner Bloom, I believe, like you said, Mr. Salvage made some pretty good, important points. So I do second the motion for us to clean it up.
Mr. Moinder, would you do a roll call, please?
Dr. Ampoma,
Approved.
Commissioner Bloom,
Approve.
Madam Chair,
Approved.
the motion carries.
All right, let's take these one by one. So there was the motion to invalidate, I believe, that was filed by Cimerex back in June of last year. In this one, they essentially ask to invalidate the division's previous order. That was, what we spent extensive time a couple months ago having a hearing on and closing out that matter. However, there was also another piece in that motion to grant a de novo competing compulsory pooling application at the OCC. And so I think, we have closed out the issue on the division's order, but I think we are granting the commission's the de novo hearing at the commission for the competing compulsory pooling matter.
Chair, I would just ask if, let me say that again, Madam Chair. I would just ask if we haven't already granted the de novo hearing for competing applications in our order that I think was related to the parties of record. I would guess we could reconfirm it, but I don't know that that's necessary.
Commissioners, my recommendation is you can grant the motion insofar as the matter will proceed to competing applications hearing. Otherwise, the remainder is denied. I think that cleans the motion up, even though you're right, Commissioner Bloom. I think it's R21679 already deals with this, as does the amended order. But just for the sake of clarity, I think that's what I'm hearing the commission discuss. So just some wordsmithing for you.
Is there a motion to grant Cimerex's application for de novo hearing at the commission for the competing compulsory pooling case and deny the remainder of the requests in the motion?
Madam Chair, I so move.
Madam Chair, I do second the motion.
Mr. Moinder, would you do a roll call, please?
Yes, Madam Chair. Dr. Ampoma,
Approved.
Commissioner Bloom,
Approve.
Madam Chair.
Approved.
Motion carries. Also, I will do an omnibus order dealing with all three of these motions for your entry, Madam Chair.
Okay. Great, thank you. All right, the second motion was filed by Mr. Padilla, I believe back in June of 2021. Again, it was a motion to dismiss the application, basically saying it was premature at this point. And I believe, to be specific, when I'm saying application, it was the competing compulsory pooling application. Is there a motion to deny Colgate's motion to dismiss Cimerex's application for competing compulsory pooling de novo hearing at the commission?
Yes, Madam Chair, given where we are at now in this case, I would move to dismiss this motion.
And Madam Chair, I do second the motion.
Mr. Moinder, would you do a roll call, please?
Yes, Madam Chair. Dr. Ampoma,
Approved.
Commissioner Bloom,
Approve.
Madam Chair,
Approved.
the motion carries.
All right, I think third and final was Colgate's motion to reaffirm the division's, I'm sorry, the commission's order. And, you know, it seems as if we are making modifications to that order to be more clear as to what the intent of was of the commission. What's the maybe best way to potentially address that, Mr. Moander, if we, you know, are making if we're amending that order, are we essentially denying the motion to reaffirm?
I think that's correct, Madam Chair.
Okay. Then based on the commission's discussion earlier regarding the amendments to the past order, is there a motion to deny Colgate's motion to reaffirm the commission's order? Did we lose Commissioner Bloom?
I think so.
Probably.
Okay. Commissioner Bloom, are you there? He appears frozen.
In and out.
Oh, we can hear you.
Okay, let's see. Madam Chair, can you see and hear me okay?
Yeah, now we can.
Okay, okay. I think I'm sorry, if we could just back up, the
Yep.
last thing I heard was you asking Mr. Moander to talk about how we could deal with this.
Yeah, so I think I asked if there was a motion to deny Colgate's motion to have the commission reaffirm its previous order based on the discussion earlier from the commission, and that the commission is asking for an amended order. Is there a motion to deny Colgate's motion to reaffirm the order?
Yes, Madam Chair, I would so move.
Madam Chair, I do second.
Mr. Moinder, would you please do a roll call vote?
Yes, Madam Chair. Dr. Ampoma,
Approved.
Commissioner Bloom,
Approve.
and Madam Chair,
Approved.
motion carries.
Okay, everything is buttoned up. And it sounds like we will be seeing Mr. Savage and Mr. Padilla once again in August.
Madam Chair,
Yes.
permit me. Might we need more than one day to hear the competing applications? Should we look at availability on the Friday following our regular Thursday?
There is always a possibility with competing compulsory pooling applications that they can go longer than a day. I am available the 12th as well as August 11th. Dr. Mpoma.
Yeah, I'm also available.
I can hold that on my schedule, Madam Chair.
Okay.
Okay.
And the parties had no issue with that?
I'd like to check with my clients whether or not we have witness availabilities. I believe Mr. Moander already addressed that, but if we can check, be a good idea.
And as long as the parties are communicating with any of those issues, it usually isn't a problem. And I have no doubt that with this set of attorneys that we will know and we will hear about these if there are issues.
I'm clear on those days.
I'm clear. It'd be good to confirm with the client, Mr. Molinder, but that should work.
Well, I believe you guys are going to have to also file, I think there's already an application in the system, so there's probably going to have to be a continuance filed in the portal anyway, so you're gonna need to clean that piece up as well. So maybe you can confirm those pieces for the filing.
Yes, thank you.
Okay. Great. All right. Were you going to say something, Mr. Molander?
I was actually going to say when you call the next case, the 22309, I don't actually see any counsel in attendance today. But I've got a few things I want to address with once we get to that.
Go ahead. I don't see any of the council either.
So, Madam Chair, there was some confusion, and I talked to a variety of attorneys on this. So Longfellow submitted an unopposed request for dismissal, and upon a more detailed reading and discussion with multiple attorneys about this request for dismissal, the way I initially read it, is not how the parties are seeing, or at least one of the parties I think are seeing it. It's an attempt to dismiss the underlying division application in this case, which would effectively obliterate the division order and negate any basis for this appeal. I am not convinced that that's appropriate here. There was no response filed to this, but what I think is more important is that the counsel for Spur filed a motion to continue that was not opposed. And so that was filed, I think, less than 2 days ago, or around 2 days ago, so it's not in the system yet. My suggestion on this is that the commission grant the continuance and deny the dismissal, because it has the commission has not ruled on that dismissal. So, well, I guess to put that in proper order, the commission deny the request for dismissal and grant the motion to continue and set this for July and get a status conference on this.
Should we get a status conference in July, or should we hear the case?
Well, that's up to you. Actually, because I'm always curious. My thoughts on this is it might be useful for the commission to get a handle on what's going on, considering the unorthodox effort to try to dismiss a division application at the commission level. But if the commission wants to proceed to hearing, it's certainly within your purview to do so.
Okay, I think denying the dismissal makes sense. And setting it for July does as well. I guess the decision point is, well, if the other commissioners agree, the decision point would be whether or not they come in for a status conference or we schedule the hearing. I'm concerned that if we schedule the hearing, they're just going to continue it or try again.
You know, Madam Chair, I appreciate the desire to push some of these to hearing, but I do think that a status conference to get a sense of what the parties are going to need, scheduling to make sure that all the witnesses can be there, especially if there's going to be a need for consecutive days of hearing, which some of these thus far in this year the cases seem to go into day 2 pretty frequently.
Okay. All right, so in de novo case number 22309, application of Spur Energy Partners for compulsory pooling. Is there a motion to deny their motion for dismissal and continue the case to July and set a status conference for the regularly scheduled OCC in July? It looks like you're talking, Commissioner Bloom, but you're muted.
Madam Chair, I so move.
Madam Chair, I second.
Mr. Moander, would you do a roll call vote, please?
Happily. Dr. Mpoma,
Approved.
Commissioner Bloom,
Approve.
Madam Chair,
Approved.
the motion carries.
Okay. Is there any update on pending litigation?
Madam Chair, I'm going to suggest doing a quick vote on the motion to continue, even though you've got the scheduling lined up. Let's tie off that motion.
Okay. Is there a motion to approve the motion to continue until the July regularly scheduled hearing where we will set a status conference?
Madam Chair, I so move.
Madam Chair, I second.
Would you do a roll call vote, please?
Yes, Madam Chair. Dr. Mpoma,
Approved.
Commissioner Bloom,
Approve.
Madam Chair,
Approved.
motion carries. And for prior discussion, this matter will be set for status conference in July.
Okay. Is there an update on pending litigation?
Madam Chair, nothing has changed from my last report just under a week ago. I have no insight into what the Court of Appeals is doing. So, but I would like to think that we should get something from them in the relatively near future, as this matter's been sitting before it since approximately Thanksgiving of 21. But so nothing new.
Okay. Is there any other business before the commission? Hearing none. Our next meeting is on July 14th, 2022. And with that, it is 10:20 and we will adjourn for the day. Thank you.
Thank you. Bye.
And this is Mary. I'm sorry, Dr. Mpoma, I beg your pardon.
Oh, go ahead, Mary.
I just wanted to beg